Well, good morning and welcome, everybody. Thank you for joining us for today's Fundamentals in Healthcare Law webinar focused on medical malpractice in Idaho. This is the second of 12 webinars in our Fundamentals of Healthcare Law curriculum. Our next webinar is scheduled on Wednesday, November 17th from 8:30 to 9:30 a.m. My name is Jason Kapster, and I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome you to today's presentation. Thanks again for taking time out of your busy schedules to be with us this morning. Before I turn the time over to our presenters, I'd like to take just a quick moment to cover a few housekeeping and logistical items. First, today's webinar is being recorded, and you will be provided a link via email to the recording within 24 hours to share with your colleagues and teams. Also, this email will include a copy of today's PowerPoint presentation, so you don't have to frantically take notes throughout the discussion. Second, we'd like today's webinar to be as interactive as possible, so please feel free to submit questions using the chat feature throughout this morning's discussion. We'll also carve out time at the end for Q&A. And finally, it's important to note that today's presentation is considered a general source of information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting legal counsel. And so with that, I'd now like to turn the time over to my colleague, Dylan Eaton. Dylan is a shareholder in the firm's Boise office and focuses his healthcare practice on defending physicians and medical providers on litigation and administrative matters. Dylan, I'll turn the time to you and make you the presenter.
Thank you, Jason. Good morning, everyone. Thanks for attending. We've got great presenters today. I only have about 10 minutes, so I'll try to be as brief as possible so you can hear from the other terrific presenters as well. As Jason mentioned, I've been practicing law for over 17 years, and a good portion of that has been medical malpractice defense. So glad to have an opportunity to talk to you briefly today. The topic I was asked to speak about is pre-litigation screening panels. So that'll be the vast majority of what I'm talking about. But I did want to briefly cover just, what's a licensing board going to contact you about? Sometimes physicians or other medical providers will indicate on an application that they have a pending malpractice suit. Oftentimes they'll be contacted because the board will then send a letter saying, tell us where you're at with that lawsuit. And oftentimes we'll help the medical providers respond to those. Additionally, you may hear from a licensing board because there's been a complaint against your license. Oftentimes, such as at the Board of Medicine, or there is a form that a patient or someone that wants to complain about the care usually being provided can submit to that licensing board. And then there's a process for dealing with that I'll hopefully have a brief moment to talk about later. And then separately is the pre-litigation screening panel, and that's a confidential and independent process that is independent from a complaint against your license. So please read the paperwork that you get from the licensing board, especially from the Board of Medicine, because there's often a lot of confusion as to, is this a complaint against my license or is this a pre-litigation screening panel? And that's important because, this, as we'll talk about, the pre-litigation screening panel is confidential and an independent process. I take the position that those don't even need to be disclosed. When they're asking about malpractice suits, those types of things in an application or a renewal, because they're confidential, non-binding, and it's my understanding, at least the Board of Medicine is supposed to keep that separate from a complaint against your license. Now, what is a pre-litigation screening panel? I often call it a PLSP. Well, it requires a person, usually a patient, who wants to sue a medical doctor or an acute general care hospital for damages in a malpractice action to first go through a process before they proceed with a lawsuit. And the purpose is to give the parties an opportunity to have it independently evaluated as to the merits of the complaint against the care being provided. And also it gives the parties an opportunity to discuss early whether settlement or an early resolution is appropriate or not. Obviously, if there's a settlement with a medical provider, you need to be cautious about that, because if there's any payment, that can usually be reported to the National Data Bank. This process does not apply to other medical professionals such as nurses or even physician's assistants. Now, a MD can be a supervisor for a physician assistant, so their supervision of a physician or PA could be at issue potentially in a PLSP process. This is not an uncommon process in Utah, for example. I'm not licensed there. I'm not licensed in Nevada, but just so you know, they have a similar pre-litigation screening panel there in Utah as well. In Nevada, they require an affidavit from a medical expert be filed to support that there was potentially negligent care before you file a lawsuit. Now, there's a specialist at the Board of Medicine that will coordinate this, but at the end of the day, it's really the panel that's making the decisions. And what's the panel made up of? It's made up of an attorney, a physician, and a layperson. The attorney's the chair. Hopefully the physician is of the same practice area as the doctor that is getting, or hospital, the doctor that is getting complained against. If it's a hospital, oftentimes it'll be an administrator for a hospital. And then the lay person, there's a panel of lay people that will change. If you have an objection to the physician, usually they only give you about 5 days to object to them. That may be because you think there's a conflict or some bias there. How's the process initiated? Well, the complainant will file an application that's on the Board of Medicine website, and then they need to serve a copy of that application on the respondent, the physician or the hospital. And of course, the application must set forth in reasonable detail what the complaint is about the care, when it occurred, who was involved, etc. You may represent yourself, or you may appear with an attorney, but the attorney needs to be actively licensed to practice in Idaho. There needs to be some approval by the Idaho State Bar that that attorney can participate in the PLSP process. And then the process is set up a telephone call, schedule the hearing. It's usually scheduled about 60 days out. And it's a very fast process. It only takes 90 days. And it has to take 90 days by statute. So the panel needs to get out an advisory decision within 90 days of the commencement of the proceeding. What are the obligations of the physician or the acute care general hospital? Well, you want to submit relevant documents and exhibits. This is why it's helpful to have an attorney to help you decide what's relevant and how to organize that. Often that will be records from the patient's chart, but it could be other records as well. On rare occasions, I've seen affidavits from experts be presented if it's a convoluted or complicated care issue, and the standard of care is unique. And sometimes to support the care provided by the doctor, an expert affidavit will be provided. And then you'll need to talk with the panel. It doesn't have to be. In my experience, it usually is not. You're not sworn in under oath, but you can be. But there's no transcript of the recording, but the panel may be taking notes and then that their notes of what you said may be reflected in their advisory opinion. Now, it is a mandatory process before proceeding, and I have that in quotes for a reason, with a medical malpractice lawsuit. There is some case law that says you can file the malpractice lawsuit before you proceed with the PLSP, but typically you want to, somebody that's the claimant would want to do that before filing the lawsuit. But just because it's filed doesn't mean they can proceed, and that's why it's in quotes with the lawsuit. So the case law says that doesn't mean that you can continue with discovery or set a trial. You need to get this PLSP done, arguably, before that happens. It is a defense to a medical malpractice lawsuit. If they haven't done this, in my experience, it usually gets stayed by the court and it's more difficult to get dismissed. But I think that's still a defense that you can have in your back pocket, depending on the circumstances in the case, to try to get the case dismissed if the plaintiff, the patient, or whoever is suing has not gone through the PLSP process. As I indicated, this is a confidential process and it's non-binding, and it's a closed hearing to the public. All documents are destroyed after the hearing. You eventually will get, the parties that are participating in this will usually get an advisory decision from the panel, but do not file that even if it's to your advantage with the court. It's a confidential and advisory opinion, and the court could get pretty upset if that's filed, because the statutes say it's confidential and should not be filed with the court typically. And if it is for some reason, it would need to be under seal by either party. How the panel operates, they'll usually give the respondent, the doctor, time to present their position, and all panel members can and usually do ask questions. Oftentimes they can be very pointed questions about the care and why something happened or didn't happen. It's an informal special civil grand jury. It's very informal. There's no evidentiary, no rules of evidence that apply. However, the panel does have subpoena power, so if they need to get some documentation to make their decision, they can use that subpoena power. So what's the advisory opinion supposed to address? Well, ultimately it's addressing whether this claim, they think this claim is frivolous or meritorious, and then they can also address damages and amount of money and damages they think might fairly compensate someone. However, in my opinion, they often don't reach that issue. And in my experience, they usually are just talking about the care that was provided and if they think it was appropriate and met the standard of care. How do they decide whether it's frivolous or meritorious? They're going to essentially look to see if there was a duty of care to the patient, if there was the standard of care was being followed, or if it was being violated, and if there was some compensable injury that can be addressed through financial compensation, and if the actions by the physician or the hospital were the proximate cause of the alleged injury. But the main focus is standard of care and whether it was complied with. The statute of limitations, usually it's 2 years for a medical malpractice, is tolled, meaning stayed, and while the pre-litigation screening panel is proceeding, and also for 30 days after the decision is issued by the PLSP. I talked about this is a separate issue, the complaints against your license. I did talk about that briefly. I just wanted to mention that your licensing board will handle them a little bit differently, but usually there's an informal process first where you can present information to the board and documentation to support your position. If the licensing board still thinks there's an issue, ultimately you'd be entitled to a hearing on that issue, and that usually would have rules of evidence apply, and would be a more formal hearing to see if there's going to be some sanction against your license. That's all I have time for. I will turn this over to the next speaker. Thank you.
Thank you very much, Dylan. Our next presenter that I'd like to welcome in is Dick Greener. Dick is going to cover Idaho's local standard of care. And Dick is a senior shareholder and trial attorney in our Boise office and concentrates his practice on healthcare law, representing physicians, chiropractors, and medical providers in medical malpractice lawsuits. Dick, I'll turn the time to you, and we'll advance the slides to get you rolling.
Thanks, Jason, and nicely done, Dylan. Good morning, everyone, and it's a pleasure to be here and affiliated with these other distinguished panelists who are all partners of mine in the Parsons law firm. I should add one other thing about my background. Pardon me, I don't focus solely on medical malpractice and medical issues. I also have a commercial practice that I've been involved with for some time. In terms of my time practicing law, I guess I'll just put it this way. I don't care to even admit how long I've been practicing, because I can't believe I've been practicing this long. But I think you'll find when I'm going through this, when I talk about the statutes on Idaho's local standard of care, I will necessarily date myself, because I was practicing when these statutes were enacted, and I remember the impact, and I'm going to be talking about that while I go through my comments here today. I guess I'll start with just the basic concept that what happened in 1976 was what I regard to be really a total change of the landscape in medical malpractice cases. And it was the result of the Idaho legislature adopting the two statutes that you see before you on this particular screen. And why did they do this? Well, there was what was perceived to be a crisis in medical malpractice cases, with too many of them being brought. And frankly, the number of doctors that were being sued was causing an issue with medical practitioners obtaining malpractice insurance. There was another reason for this, and it really is a very sound one, and it's this. The debate went on about how can we encourage practitioners to go into the small rural communities and practice medicine where they don't have perhaps the most well-equipped hospital available. And the idea was, though, that in the state of Idaho wanted to encourage these practitioners to provide this service to Idaho residents. And that's why, one of the major reasons why, the local standard of care came along. And it makes sense, really, if you stop and think about it, because certainly in the middle 70s, a practitioner in a rural Idaho community did not have access. There was no internet, did not have access to all of the information. And frankly, most of these very able practitioners were general practitioners. And as a consequence, they weren't specialized in various areas. And the thrust and the rationale behind this legislation is that it was simply unfair and unrealistic to hold them to the standard of a physician practicing in a community with a more sophisticated hospital system. So the statutes remain on the books, have not been changed, and I think they accomplished their purpose. Basically, though, as an overview, I have to say this. What did they do? They created a real heightened burden of proof that was placed on a plaintiff bringing a medical malpractice case. It could not be brought as an ordinary negligence case. And you find this in the two statutes, 6-1012 and 6-1013. And Jason, if we could go to the next slide for just a minute. What I've done, and you'll be getting a copy of this, I've highlighted some of the, I don't want to suggest that not all the language is critical, but I've highlighted some of the key language here, which, and this really highlights what's been done as far as creating this more rigorous, if you will, burden of proof to remain in court in a medical malpractice case. And you'll see, and I'm not going to take a lot of time on this because our time is limited, but in the second highlighting, plaintiff must, as an essential part of his or her case, affirmatively prove by direct testimony. That's a statement that has heightened the burden of proof, and it goes on to require that the plaintiff show that the defendant negligently failed to meet the applicable standard of care of practice in the community in which such care was given. That's what I was just touching upon, and that's critical language, and not that in this particular part of the local standard of care statutes. And if we could go to the next one, and this sets really the stage and tells the practitioner what they need to do, because they have to have the testimony of a competent expert witness, and that expert witness has to lay what's called a foundation. That is, he has to show that he is qualified in the area in which he's testifying, and he has to demonstrate that he actually holds that opinion, and it can be testified to a reasonable degree of medical certainty. In addition, there's the requirement that the expert possess knowledge about the local standard of care, as I discussed earlier. So this kind of sets the stage for what has happened as a result. And frankly, if we go to the next slide, please, Jason. This legislation that I've talked about, the two that we've just gone through, when it first came on, district judges and the Supreme Court was sustaining this, were applying it strictly, if you will. I think that's the best way of explaining it. And a plaintiff expert in a medical malpractice case had to be in the same specialty as the defendant. In other words, a cardiologist had to have a cardiologist expert to testify against a cardiologist and meet all the criteria of the two statutes, or a general practitioner against a general practitioner. Now, as a practical matter, at the time, there was frankly difficulty in finding, if a plaintiff wanted to bring a lawsuit, finding local doctors to cooperate and to provide any information to the plaintiff's expert about the local standard of care. And as a consequence, alternative approaches developed, which made things a little bit more burdensome, but they worked. And that is, a plaintiff's expert could visit a defendant doctor's community. I laid this all out in the outline. Visit the local hospitals, go to the view the operating rooms, the exam rooms, the medical library, and see how the hospitals were staffed. That in and of itself didn't completely do it, but then there was there were other requirements, and they have evolved by now to this point. And what has happened in addition is there's been what I like to describe as an evolution and liberalization of the applications of these two statutes. And it became clear, and actually we were involved in litigation in one of these, it became clear that these statutes were not limited in their application solely to medical doctors. And now that wasn't well known, but with the Alrigi case that I've cited there for you, the court specifically held that healthcare providers who were licensed by the state of Idaho, such as chiropractors, podiatrists, and others, certain technicians who were licensed by the state of Idaho, were all fell under the act. And that meant that the heightened requirements in the act had to be complied with in order to maintain a case. The court also announced that in most of these cases where there's a medical malpractice case filed, there's an assertion of a claim of emotional distress or perhaps loss of consortium. And those are all basically somewhat derivative from the standpoint of they're derivative of the medical malpractice case, and there has to be compliance with those statutes in order to maintain those causes of action. So where does it take us in this day and age, if you will? And I want to get into a few of the cases, and it looks like I'm quickly going through my time here, so I'm going to try to move this along. But at the present time, there are three ways to satisfy the statutory requirements of 6-1012 and 6-1013. The first is, of course, the logical. Your expert can inquire of a local physician in the same specialty as a defendant. And that has been certainly workable for some time now. If there's a problem finding a local practitioner in the same specialty, this Fisk versus McDonald case, it's a 2020 case that I've cited here, held that this could be accomplished by talking to a physician who can demonstrate sufficient knowledge of the standard of care that's applicable to the particular defendant. Now, there are other ways as well, and they've been approved, if you will, by district courts and by the Supreme Court, and that is the expert can review deposition transcripts of local practitioners where they explain the standard of care. Also, there's a third that's been developing, and it's expanding really, and that is you can rely upon a national standard of care if it's established by state or federal regulation. Now, in some areas, for example, in the area of chiropractic, there are no such national standards that are in existence as of this point in time. But in other areas, and for example, in the neonatal resuscitation area, where you have that involve issues that arise at childbirth, the American Academy of Pediatrics has adopted the National Resuscitation Program, the NRP, and that, in my view, and this is certainly subject to challenge perhaps, but I think that that's established a national standard of care, and there's case law that establishes that. And so that's another way, and there are others that I've listed there. I won't go into all of them because in the interest of time. But the national standard of care established in this way has been expanding. It's important you keep that in mind. And I think it's an important part of this entire fabric of medical malpractice and the application of these local standard of care statutes. So Jason, you'd be kind enough to go to the next slide. And this just kind of shows the additional aspects of the evolution of case law. And for the longest time, I always thought that you had to have a medical doctor at least testifying against a medical doctor. And in this particular case, Evans versus Griswold, and this is 1997, so it was some years ago, the court determined, the Idaho Supreme Court determined that the plaintiffs out of the area ophthalmologist who was going to testify against a defendant optometrist had failed to lay a sufficient foundation to show that he was knowledgeable about the standard of care. Now, why am I mentioning this? It's significant because the court didn't hold that an MD ophthalmologist could not testify against a non-MD optometrist, even though they're different licensure requirements, they're different practitioners, and they're different educational backgrounds. That just shows how this has evolved. And I mentioned the other cases that I've cited here, and I guess I have one other topic I want to cover, so I'm going to drop down to the last. I'm sorry, Jason, could we go back to the last one for just a second, please? The last one there that I mentioned, Fisk versus McDonald. The court ruled that an out-of-area nurse practitioner who is not an MD, although certainly a talented healthcare provider, could not acquire an adequate foundation to testify as the community standard for a neurosurgeon in the particular case, but didn't indicate that a nurse practitioner who demonstrated actual knowledge of the community standard of care would have been barred from testifying in that totally different specialty. This just goes to show you how far these the cases have evolved in terms of, if you will, a loosening up. So Jason, let's go to my last slide, and I think I'm about out of time. And I'm going to talk about a recent case that actually one of the other panelists, Slade Sokol and I, were involved in together. And at the outset, the Idaho Supreme Court is still certainly applying the requirement that you have to have admissible evidence of local standard of care in order to have your expert testify, the plaintiff's expert in a medical malpractice case. In this case, the plaintiff is accusing a defendant, a chiropractic physician, of chiropractic negligence. He disclosed a very, very well qualified orthopedic surgeon from out of state who is also licensed in the state of Idaho. And he was, no question about it, but he could have qualified to testify in an orthopedic case. We took his deposition. He said he didn't know anything about a local standard of care in Idaho. He knew nothing about a standard of care for Idaho chiropractors. He thought it was basically a national standard, which incidentally, as I mentioned before, does not exist. And so what did we were taking his deposition when these admissions came forth, and plaintiff's counsel objected and said, why are you asking these questions? This is just a negligence case. I said, I don't really think so. And I bring this up just to show you that out there in the bar, there are qualified attorneys who are unaware of these requirements, such as for a non-MD lawsuit involving a non-MD, you still, within the area of chiropractic and others, as I've indicated, you still have to come forth with a knowledgeable, competent expert witness who can testify to the standard of care, the local standard of care for a chiropractor. I guess the one thing I will leave you with is, in that particular case, I remain wondering if the orthopedic surgeon could have actually done the work to familiarize himself with the local standard of care for the chiropractor in question and testified as an expert. I don't know how the Supreme Court of the state of Idaho would rule on that now, but they have certainly indicated and I think that, this is not an unfair statement. They've indicated a rather liberal bent in that direction. So I thank you all for your time and attention. Thank you, Jason, and I will sign off.
Thank you very much, Dick. We appreciate your time and your insights there. I'm now going to turn the time over to our next presenter, Kelsey Kirkham. Kelsey's going to focus on informed consent for us today. Just by way of background, Kelsey is an associate in the firm's Idaho Falls office and focuses her practice on defending medical malpractice and licensure board disciplinary matters involving physicians, hospitals, and other healthcare providers. So Kelsey, thanks for being with us today. I'll turn the time to you.
Thank you, Jason, and thank you for those who are attending and being a part of this presentation. I'm going to speak to you about informed consent. And by the time we see this in a medical malpractice action, there is the patient who is now the plaintiff who is claiming that they were not provided adequate informed consent before submitting to a procedure or to a level of care. So there are some Idaho statutes that govern the sufficiency of the consent, the form of the consent, and whose responsibility it is to obtain that consent. But the case law has established that there are 3 elements that have to be proved by a patient plaintiff in order to prove this type of claim. So the first element is non-disclosure, which really is better characterized as an insufficient disclosure. That's what we see most commonly. Second, the plaintiff must prove causation and injury as a result of that insufficient consent. So the sufficiency of the consent is when we're going to be looking at whether there was non-disclosure or sufficiency of disclosure. And the Idaho Code, section 394506, gives us a presumption of validity. So if the consent has been given such that it discloses pertinent facts to the patient such that he or she is sufficiently aware of the need for the treatment, the nature of the treatment, and the significant risks ordinarily involved in the treatment that is to be provided, such that it allows the patient to be reasonably informed in making the decision of whether to provide or not provide the consent. A key part of that is that the consent, this disclosures and advice must occur prior to the procedure. So a valid consent must be preceded by the physician disclosing those relevant facts. The significant risks ordinarily involved in the treatment need to include risks and benefits of alternatives to the recommended treatment, and taking into consideration the relevant clinical history and presentation of the patient in determining whether there's risk factors that would have a less of a risk if they were to submit to a less invasive procedure, for example. And when we're proving non-disclosure, it's the same elements as Dick just talked about for us. The plaintiff must prove that the disclosure and advice that was given, it has to be compared to a like provider in the same community of which the consent was given. So if it's a family physician, we're comparing it to the consent that a family physician would give for a particular treatment, and also in the same community. And in the same community is defined as that geographic area ordinarily served by the licensed general hospital at or nearest to where that consent was given. So it's looking at what a similar doctor would do. The form of consent will help us determine whether there are certain presumptions that will weigh in upholding the validity and the sufficiency of the consent. Consent does not have to be in writing. The Idaho Code does not require for informed consent to be in writing or in other form of express authorization. However, if the consent is documented in writing and it is initialed by the person giving consent or executed by that person, then the provider is given a pretty strong presumption that the consent is valid for the furnishing of the care. And that is separate from the sufficiency of the consent. But we also get a presumption in that case too. Not only do we have a presumption that the consent is valid, but we have a presumption that the disclosure and the advice met the level of the sufficiency of the consent that we talked about a moment ago. I think it sort of goes without saying, but the duty of obtaining this consent is upon the healthcare provider who is taking on the healthcare or treatment of the patient. That is with the caveat that employees or other staff of a hospital or provider's office, they may provide the ministerial tasks of documenting the consent that was obtained and the level of consent and advice that was given, and obtaining the requisite signatures, and that is not deemed a practice of medicine by doing so. However, if we're allowing other employees to document that informed consent, it still falls incumbent upon the provider to make sure that that consent still contains the entirety of the advice and disclosures that would be required. And we want to make sure that consents also include a broad enough scope for the procedure that's to be performed. For example, if an exploratory procedure is going to be performed, then the consent should include other types of procedures that may be incidental to that exploratory procedure in order for the consent to be valid, because it has to be obtained prior to the treatment being provided. So in order to further prevail on an informed consent claim, not only do we have to, the plaintiff would have to show that there was insufficient disclosure, but then the plaintiff must also show that the outcome would have been different, so that a reasonable person in the patient's same position would not have consented to the procedure had there been full and adequate disclosure of the significant risks that should have been given prior to the care being provided. So in other words, the plaintiff would have to show that they would have chosen no treatment at all or a different course of treatment had they been adequately informed by the physician. And then, of course, in order to prevail on the claim, they would also have to show that there had been an injury or some sort of damages that were resulted of the lack of informed consent. So just some small takeaways of best practices in obtaining informed consent. Remember that consent is a continuum, and we really have to take into consideration those patient demographics and the type of procedure that's being contemplated. And the more detail that we have in our informed consent, the much greater protection that we're setting ourselves up for proactively. The physician should discuss the treatment with the patient and document that they have addressed all patient questions or that the patient had no questions. We want to make sure that for a solid informed consent, we're closing any holes that might otherwise exist. With the presumptions that we get for a written disclosure, obtain a written informed consent whenever possible, but use those consent forms carefully and make sure that there's room for tailoring to each specific procedure and patient. And lastly, confirm the date and time of the consent and have that documented within your records to further document that it was obtained before the relevant treatment. I hope that this was helpful to everybody with the informed consent, and I'm happy to answer any questions that you might have. Thank you.
Thanks a lot, Kelsey. We appreciate your comments and your time today. Before I turn the time over to our final panelist, I would like to encourage all of you to submit questions that you may have for any of the panelists via chat, and we'll do our best to address those. Our last topic of the day is comparative negligence. I'd like to welcome in Slade Sokol. Slade is a shareholder in the firm's Boise office, and he concentrates his practice on medical malpractice defense and complex commercial litigation matters. So Slade, I'll turn the time over to you to wrap up today's webinar.
Thank you, Jason. Thank you, everyone, for being here this morning. My topics for today's presentation are generally going to be comparative negligence, damages caps, and a number of other medical malpractice defenses that arise when defending a medical malpractice case. So what is comparative negligence, and how does it apply in a malpractice case? This is the statute that was enacted in 1971. It's Idaho Code 6-801, and it sets forth Idaho's comparative responsibility requirements and statute. There are a number of other statutes that have related elements to comparative negligence, but what does this say essentially? And I break it down into two parts. The first part is the negligence of a plaintiff does not bar recovery by the plaintiff for damages for an injury if the plaintiff's negligence is not as great as the defendant's negligence. It's part number one. The second element is that even if the plaintiff is negligent, and that negligence is less than the defendant's negligence, the plaintiff's damages are subject to reduction for the amount of the plaintiff's negligence. And this is on a scale of, it's a 100%, 0 to 100%. And the finder of fact, generally the jury, is asked to attribute negligence to the plaintiff and then also to the defendants, and the total amount together is 100%. And so how does this work in practice in a medical malpractice case? First of all, comparative negligence means that the negligence of all the parties, the plaintiff and defendant, and there can be numerous defendants, are compared to the other parties by the finders of fact. An example here is if a defendant provider can establish that the plaintiff was negligent in failing to timely seek treatment for an alleged injury resulting from alleged malpractice, and the provider provides expert testimony that the plaintiff was negligent in seeking treatment, then the jury can attribute negligence to both the plaintiff For that, failure to timely seek treatment, as well as the defendant for causing that injury. Let's say the defendant is 55%, the jury finds the defendant 55% at fault, and the plaintiff 45% at fault. There, the plaintiff's negligence is less than the defendant's negligence, and so the plaintiff can recover. But in this example, the damages that are awarded to the plaintiff by the finder of fact would be reduced by the 45%. Second, if a plaintiff's negligence is determined to be equal or greater than the defendant's negligence, then the plaintiff cannot recover. Example, switch the numbers from the last example. The plaintiff is found to be 55% negligent and the defendant 45% negligent. Plaintiff cannot recover. Defendant and the plaintiff's not entitled to any damages. Third, if plaintiff's negligence is found to be less than the defendant's negligence, then the plaintiff's recovery is diminished by the percentage of the plaintiff's negligence. And I went over that in the first example. 55% defendant was negligent, 45% the plaintiff was found to be negligent. Whatever amount is awarded to the plaintiff, then whatever award that is reduced by 45%. And then finally, the negligence of each defendant is compared to the negligence of the plaintiff. So let's say there are 3 defendants, 1 plaintiff. The jury finds that the defendant number 1 is found to be 55% negligent. Defendant number 2 is found to be 25% negligent. The third defendant is found to be 10% negligent, and the plaintiff is found to be 10% negligent. And so those numbers all add up to 100%. Well, the plaintiff can recover from the first and second defendants because they had 55% for number 1, 25% for number 2, and the plaintiff was 10%. And so be able to recover against those 2 defendants. However, the plaintiff will not be able to recover against defendant number 3 because defendant number 3 had the same amount of negligence attributed to he or she, 10%, as the plaintiff did. And so it's equal to, and so therefore the plaintiff cannot recover against defendant number 3. So that's comparative negligence, very generally speaking, in a medical malpractice case and how it is applied. Idaho's damages caps. There's a number of them. There's a punitive damages cap. It doesn't come into play a lot in medical malpractice cases. I'll briefly say that it's $250,000 or 3 times the amount of compensatory damages that are awarded a plaintiff. I was able to find one case as an example. It was actually a recent case where a provider was a punitive damages claim was allowed to be asserted against a provider who was inseminating his patients with his own sperm. The court found that that was fraudulent, malicious, and outrageous conduct and allowed the plaintiff to assert punitive damages claim, which then the jury would be asked to decide whether or not punitive damages should be awarded. But the damages cap that comes up most often is this one here. It's Idaho Code 6-1603, and it's the non-economic damages cap. It was enacted in 1987. And before I get into this, a little bit of background. What are non-economic damages and what are economic damages? Well, non-economic damages are defined as non-monetary losses, including but not limited to pain, suffering, inconvenience, mental anguish, disability, disfigurement, and all those kind of damages that are incurred by the injured party. And then they also include emotional distress, loss of society and companionship, consortium, loss of consortium, impairment of a parent-child relationship. And so those are kind of damages where you can't exactly quantify. They're unlike economic damages, which are verifiable monetary loss, medical bills, out-of-pocket expenses, loss of earnings, et cetera, et cetera. And so there isn't a cap on economic damages, which makes sense because if you're suing a provider for medical malpractice and you can establish the amount of damages that you actually lost in a specific dollar amount, there shouldn't be a cap on that. However, there are a cap in non-economic damages because it's subjective component. And what the Idaho legislature did was enact this statute in 1987. And in between that period of time, 1987 to June 30th, 2004, the limit or cap was $250,000. Post July 1, 2004, you can see the language here, and it changes every year on July 1st, and it's slowly been going up for the last 15, 17 years, and it's gone up all the way to, as of right now, the cap is at $399,430 and change. So, and that's a matter of tort reform too. I'm sure the legislature wanted to curtail large non-economic damages award, and they did so here. But there are ways to get around non-economic damages cap. And so what are some of those exceptions? And I'll briefly talk about, there's two of them. The first one is if the provider's conduct is determined to be willful or reckless. And number two, the defendant his or her conduct is determined to constitute a felony under state or federal law. There is not a lot of medical malpractice law that applies that second exception. I guess the case that I was talking about earlier with the insemination with the provider's sperm could probably constitute a felony. I would certainly think so, but I don't believe that came up. What did come up is this reckless. This comes up once in a while in medical malpractice claims. And what does reckless mean? And what the Idaho Supreme Court has found is that reckless conduct requires a conscious choice of a course of action, either with knowledge of the serious danger to others involved in that conduct, or with knowledge of facts which would disclose this danger to any reasonable man or woman or provider. So it's an objective standard, and an example of this recklessness being applied and being found was a couple of years ago. Some parents of a minor child brought an action against the physician for negligence and recklessness for failing to diagnose the child's developmental hip dysplasia. The district court allowed the reckless instruction to go to the jury, and the jury found recklessness because a number of factors. The parents continually had concerns and expressed those concerns to the provider about their child's condition. There were objective signs of dysplasia, and the imaging, radiological or otherwise, was simple, could have been ordered, should have been ordered, and it would have been conclusive and found the hip dysplasia. And the problem compounded over time. The child grew older and made it more difficult to address this condition. In that instance, the jury found recklessness, the Idaho Supreme Court affirmed, and the cap was disregarded. Other defenses that come up, a big one, I think, is, and then there's numerous ones. I'm just going to briefly talk about statute of limitations. That's Idaho Code Section 5-219. And that statute requires that a cause of action must be brought within 2 years from the time of the occurrence, act, or omission complained of, and when some damage is objectively ascertainable. This last portion, some damage objectively ascertainable, that language is not in the statute. That's an issue of case law that the Idaho Supreme Court has read into the statute. And how is that applied? Well, there's a case that recently came out where the parents of the wife went and had a tubal ligation performed and she was informed by the provider that it was permanent. She wouldn't have kids anymore. Well, guess what? She became pregnant, and she brought an action against the provider for medical negligence. The district court applied the 2-year statute of limitations from the time of the actual tubal ligation, and the court dismissed the parent's claim on summary judgment. Well, they appealed, and the Supreme Court reversed. And here's why. The Supreme Court found that the district court misapplied this some damage that was objectively ascertainable portion of the requirement of the statute of limitations. The court found that the sum damaged was not objectively ascertainable until the wife became pregnant. And the reason because of that was because the ability to find out that the tubal ligation was not successful involved a very difficult, painful, expensive surgery. And for that reason, and of course they had medical expert testimony to testify to that, because of that reason, they found that the fact that the tubal ligation was not correctly performed, that was not objectively ascertainable until she actually became pregnant. And so the court reversed the summary judgment decision on the statute of limitations grounds. There are 2 exceptions to the 2-year statute of limitations, and they make sense. The first is where there is a placement and inverted accidental or unintentional leaving of any foreign object in the body. Let's surgical sponge, a scalpel, or where there has been an injury to a patient that has been fraudulently and knowingly concealed. Don't come up a lot, but under those circumstances, and I'm going to make a correction here, it's 1 year after the injured party knows or in the exercise of reasonable care should have been put on inquiry regarding the condition or matter complained of, or 2 years, whichever is later. So it's one or the other. So for example, it could be 3 years after the surgery that the patient is having some pain in the abdomen. There are some radiological or other imaging done, and there's a scalpel that's in the abdomen, and that would start the 1-year statute of limitations, because of the 2 years, because that'd be the longest, and so it'd be 1 year from that time. One other defense that comes up, and I got 1 minute, is, and you know, it's a defense. I don't know if I call it a affirmative defense, but this is it's collateral sources, and the collateral source rule, generally speaking, stated that defendants couldn't take advantage of an injured party's insurance or ability to get other recovery from other sources such as insurance or governmental programs. The defendants didn't get the benefit from that. Well, Idaho changed that, and this statute was enacted in 1990, and it precludes plaintiffs from recovering double damages, if you will. And a brief example of that is Medicaid and Medicare write-offs. The Supreme Court treats those as collateral sources. It hasn't actually come out and defined them as collateral sources. But essentially, what the court has now said very recently is that medical bills should be presented to the jury in the amount that was invoiced by the care provider, not the amounts after Medicare or Medicaid write-offs were applied. This was a significant change in the law before this case came out in 2020. And I think a year before that, defense counsel could generally get the court to only allow the jury to see the bills that had the write-offs. And now we can't do that anymore because of these decisions. And what that essentially does in theory is that if the jury is allowed to see the medical bills without the write-offs, then the amount is higher, which in theory affects the amount of non-economic damages that are awarded and increases them. And so that was a hit to the defense bar. With that said, that's all I have, and I believe Jason will anybody has any questions, be more than happy to address them.
Hey, thanks a lot, Slade. Great job. Appreciate your time and your insights. As we wrap up here today, I want to just take a moment to extend a huge thanks to all of you for taking time out of your busy schedules to be with us for today's webinar. I'd also like to extend a big thanks to our panel and my colleagues, Dylan Eaton, Dick Greener, Kelsey Kirkham, and Slade Sokol for preparing today's information and the materials. We hope that you found this helpful. We hope that you found it informative. We hope you'll come back for our next webinar, which is scheduled for Wednesday, November 17th from 8:30 to 9:30. This webinar is going to focus on healthcare fraud and abuse. All of you will receive an invitation for this event in the coming days, so please keep your eyes peeled for that. And then just lastly, by way of reminder, as I mentioned from the outset of the call today, we will be providing you with today's PowerPoint presentation and a recording link to today's webinar so you can share with your colleagues and teams that were not able to join us today. So again, to all of you that participated in today's webinar, thank you for your time. We appreciate your support. And if there's anything that we can do to help you with these issues, please feel free to contact any one of our panelists. And with that, thanks again for your time, and we hope to see you on November 17th from 8:30 to 9:30. Thanks again.